Hi everyone, this is Dr. Eldridge, and I wanted to give you a quick rundown on how you read a legal case, because you have your first legal case that you're briefing this week, and so I wanted to make sure you all understood how you go about reading the legal case. Now, this is one of our shorter cases actually, which is a good thing, because sometimes having a short case at the beginning for the first time you're doing something of this nature or follow-up from your lower division law class is a good thing. So we're looking right now at the Exempleware Corporation versus Versata software case. Now, if you look at that, right below the case name and citation, which this is your citation, is what we call the subsequent history and the information on core terms and things of that nature. You don't have to worry about any of this information, okay, because this information isn't what you're looking for. What you want to do is you want to go down to where the opinion, this part, actually begins, where it says opinion, because that's where it's going to start talking about the case and painting the picture of the case. And remember that, you know, before anybody can make a decision on anything, you always have to give background information, especially if you know you have an audience. And of course, in the judicial system, there's always an audience, and that's going to be, in the end, the parties and subsequently the public, as we're the public at this point in time. So what you want to do is you want to go down to the opinion and start looking for key terms. Whenever you see the word background, that means that the court is going to start talking about the case, the background. It's going to talk about the facts of the case. It's going to talk about how Exempleware came to sue Versata and the other defendants. It's going to talk about what happened that caused the plaintiff to sue the defendants. And it's also going to talk about what led to the appeal. So it's very, very important that you pay attention to the background always, because that's going to tell you what is going on with the case, and it's going to paint the picture of the case. That's also very important when we go to creating the case brief, because your facts are your background, and so you want to make sure that you're very specific with that information. Now, up here real quick, if we look at this information, it talks about the fact that the opinion is looking at an order denying plaintiff's ex parte application for a temporary restraining order and denying plaintiff's request for expedited preliminary discovery. We're not so much concerned about the expedited preliminary discovery, but we are concerned about this part in particular, the application for restraining order, okay, because that really is what we're talking about, going to the heart of the case. So when you're looking at an issue, you're always talking about what's the heart of the case. So it talks about on December 4, 2013, the court held a hearing on plaintiff's ex parte application for a temporary restraining order and the other requests, and a request for the expedited discovery. Counsel for plaintiff and defendants argued at the hearing, and for the foregoing reason, the court denies plaintiff's application for a temporary restraining order and the order to show cause, etc. So now the court is looking at this on appeal. So now what we're looking for is, we've got the background here, so we know these are the facts of the case pretty much, right? But now we need to go down, we need to say, okay, but what's the issue? What was the question or questions that the court had to decide? So we're looking here at the court saying, Exempleware filed this application for a temporary restraining order. Okay, so if it filed an application for a temporary restraining order, and that is one of the primary issues in the appeal, then we know that the issue, the question that the court has to resolve, has something to do with this temporary restraining order. So when you're looking at the case, you want to look at what is jumping up and what are you looking at as the primary issue or issues in the case. So now what we have is a discussion underneath that. And when you have the discussion, what that means is now the court's going to really start identifying the issue in the case. And so it talks about the temporary restraining order. The standard for issuance of a temporary restraining order is the same for that as that for issuance of a preliminary injunction. So if we know that, now what the court is going to do is it's going to start talking about the requirements for issuing a temporary injunction or a preliminary injunction or a temporary restraining order, TRO, whatever we want to call it or refer to it. It's all one and the same. And now we're going to talk about what are the requirements for that. And so this case boils down to what are the requirements for that, right? So in order to obtain a preliminary injunction, a plaintiff must establish that he is likely to succeed on the merits. So you have to look at, okay, then now what are we looking at? What are the merits of the case? So you have to look at the elements, and this is what the court had to decide at this point. Did the plaintiff meet, or the moving party meet, the requirements to establish the need for a temporary injunction, right? And so that's what you want to look at when you're looking at, well, then what's the issue? You want to look at the key factors that the court's trying to identify as the issue. And sometimes it will say, in order to, if you're looking at obtaining some kind of relief, you have to do X. In order to get this, you have to show X. That's generally the issue in the case. Then underneath that is where the court starts talking about the elements of the law, and the court starts talking about how the facts of the case either did or didn't apply. And that's where you start looking at the opinion further and talking about a court's rationale. Then you go down to the request for expedited limited discovery. I'm not concerned about that issue as much because we're really looking at the heart of the case and what is at the heart of the case. So think about that. And then when you have conclusion, the court finds that exemplaware has failed to demonstrate that it will what? And now it's telling you, it's giving you your direct answer to your question. And your holding is always your answer to the issue. And the issue is the question. So you're looking at that. Always look at the conclusion. Understand, though, that the term denied or reverse or remanded and those terms, those are not holdings. Those are results of holdings. Here is where your judge tells you his or her holding. And up here is where the court tells you why it held as it did in this particular case. Okay, and mixed in here is the law, so pay attention to when the court looks at a case and says pursuant to X case, or refers to a case when it's talking about the law in general itself, and then you have the case showing after it. Okay, so pay attention to those things. That's how you read a legal case, and I know probably we're going down to the bottom, then we're going back into the heart of it. You can read it as it is, but what I'm wanting you to do is pick out the key elements of the case so you understand what you're reading and it's more clear. So now what we've done is we've identified the background is the facts of your case, and also oftentimes mixed in here, either at the beginning or the end, the court is going to spell out the issue. Then you have your discussion, which is your rationale section, which is where the court identifies the law, and the court identifies again the issue, and then talks about how the facts relate or don't relate to the law. In other words, how the facts actually meet the elements required or how the facts do not fit into all of the elements required. And then at the end, you're going to have your conclusion, which is where the court's going to be specific and tell you how, in fact, it actually answered the issue in the case. I hope this is helpful. If you have any questions, of course, don't hesitate to contact me via email or otherwise. Thank you.